Yes, sir, we're live. All rise. Court of Appeal, Land Enforcement District of the State of Florida is now in session. The Honorable Joshua A. Mize, Judge presiding. All persons having business before the court shall near give attention of the will be heard. God save the United States of America, the State of Florida, and that honorable court. Please be seated. All right, everyone. Welcome to this oral argument session of the 6th District Court of Appeal. My name is Judge Joshua Mize. To my right is Judge Mary Alice Nardella. We're also honored to have with us today Judge Michael Huey of the 13th Judicial Circuit. And we're grateful for his time, and we're grateful to the Florida Supreme Court for allowing him to sit with us.
Thank you for having me.
We have one case on the docket today. It's 23-846, Basilio and Tamate Zolo versus the state of Florida. Appellant, we normally put 5 minutes on rebuttal, but you can change that if you'd like.
Yes, you are 4 minutes for rebuttal.
Okay, I think I know how to change that. Yes. All right, whenever you're ready, counsel.
Good afternoon. May it please the court. Actually, it's odd to say good afternoon. Most of my appellate arguments are in the morning, but thank you for rescheduling this around my availability. I had a third DCA argument yesterday and could not join the calendar yesterday that you had. My name is Ben Cuny. I represent Basilio Zolo and present his case on appeal. As the court knows, he was convicted of attempted second-degree murder and various counts of child abuse. We've raised a number of procedural and evidentiary issues for consideration by the court, including, to summarize, the admissibility or inadmissibility of the pretrial statements of the testifying children, the improper child hearsay. We have challenged Mr. Zolo's statement to the police on involuntary grounds, challenged the sufficiency of the evidence, and have objected to the voluntary intoxication instruction used in this case.
Counsel, both as to the confession and to the child hearsay statements, I noticed in your reply brief, the state in their answer brief brought up Carvey State. I noticed you didn't respond to it in your reply brief. Is there a reason for that?
Your Honor, I believe that the discussion that we had in the main brief was sufficient, but I'm glad to address any questions the court has about that.
Can you explain to me how Carr isn't binding as to the issue of whether the objections was preserved below?
It appears based on the decision that the objection or lack of a sufficient objection was not enough to present the issue, and that a fundamental error claim, unless raised initially in the brief, probably does not survive. So although the trial,
Are you conceding that your errors were not preserved?
Your Honor,
At least under Carr?
basic, an application of Carr would suggest that there is not a sufficient preservation of error. We believe that the totality of the objections raised should be enough for this court to analyze the effect of those issues, but we do agree that trial counsel was not sufficiently clear in objections to make the issue crystal clear for this court. Under the law that existed, we think it should be sufficient, but recognize the more recent limitations.
So under the law that existed, the law that existed was Carr, right? It existed at the time. Seems like you're conceding Carr means, at least as to the confession and the child hearsay statements, Carr would, which is binding on us, it's a Florida Supreme Court case, we don't get to not follow it. It would render both of those two errors unpreserved, correct?
I think, Your Honor, the best I can say.
If you have a way to distinguish Carr, I'm all ears.
Yes, sir. So I would ask the court to consider, just give me a moment to get to my point on this. I would ask the court to consider that in the pretrial litigation, the defense made clear that there was.
You got a definitive ruling in the pretrial litigation, right? And which is exactly what happened in Carr.
Yes, sir.
And in Carr at trial, when the evidence that was subject to the pretrial ruling sought to be admitted, the trial court asked the defendant's attorney, any objection? Defendant's attorney said no objection. And the Supreme Court held that despite, I think section 90.104's language, saying you don't have to renew an objection once you have a pretrial ruling, that by saying no objection, even though they didn't have to renew it, by saying no objection, they affirmatively abandoned it. That seems to be exactly what happened here. I don't see a single distinguishing fact as to at least as to the confession and the child hearsay statements. I see not a single distinguishing fact between this and Carr. If there is one, I'm interested to hear it.
Yes, sir. Although Carr did not involve voluntariness of a confession, the general rule is that the trial court is required to make a voluntariness finding. The fact that the statement gets admitted into evidence and was not preserved should not be sufficient to stand as a trial court determination that it is a reliable and voluntary statement, and the issue should be reviewed as a matter of law. Carr does say.
I don't understand what you just said.
Yes, sir.
So there's a pretrial ruling, right? And so the issue is not whether your objection is well taken, not whether you were right or wrong. The issue is whether or not that is preserved and whether you have to renew it, right? So to me, Carr, it's a preservation issue. It doesn't pertain to the substance of your objection or whether it was right or wrong. It maintains to whether or not you successfully preserved it or whether you had to reassert it. And so to me, the only relevant facts for Carr are not the substance of the objection or why it was wrong or right. It's the preservation analysis. And the preservation analysis was there that by saying no objection, the defense attorney affirmatively abandoned their objections, whatever the substantive objections were and whether they were right or wrong. As to the preservation part of it, is there Is there anything about Carr that is distinguishable from this case?
So Carr, and I apologize for seeming to be difficult on this, Carr does say, if you don't renew the objection, a prior fully formed ruling does not stand for appellate purposes. And we recognize that.
Okay.
The constitutional, our view is the constitutional requirement that pretrial statements, custodial statements, be only heard by the jury if they are voluntary and knowing, should stand to allow this court to make that evaluation. If it doesn't, then certainly defense counsel did not adequately preserve a constitutional issue.
Okay, that's helpful. So your argument is that even though Carr would otherwise be applicable, because this specific evidentiary issue went to a constitutional right, that Carr should not apply to objections based on constitutional rights?
In this particular circumstance, given the enormity of the use of the statement, the circumstances undermining the knowing and voluntary statement, and the nature of that statement by the defendant, this court should determine that this is the type of error sufficiently preserved in written rulings, evidentiary determinations, and plainly the defense lawyer, we believe, statement was intended to suggest no other objections, Your Honor.
Okay, I'm not arguing with
waiving.
you whether Carr was correct in how it evaluated the statement of defense counsel. We have to follow it whether it's correct or incorrect, right? So I don't have any reason to dispute what you're saying about what the defense attorney said. I'm just saying Carr gives us consequences to what he said, whether we agree with those consequences or not, right?
Well, yes, Judge, Your Honor, except in the context that the court could construe the no objection statement as akin to no other objections, Your Honor.
But how can we do that in light of Carr, right? Didn't the attorney in Carr used the exact same words, right? There's literally not a syllable. There's not a letter of difference between what defense counsel in this case in the trial below said and what the attorney in Carr said. So the Florida Supreme Court in Carr interpreted that as an abandonment. I'm not saying that was correct. I don't sit on the Florida Supreme Court. I'm just saying they said that's an abandonment. How can we interpret the exact same words differently than the Florida Supreme Court did?
Only the context, Your Honor. We believe that the context and not knowing the trial record in Carr, just knowing the appellate determination, it appears the court was very clear that this was an abandonment of the issue. Almost as though it's recognizing resignedly, yes, I have nothing to say about this. Whereas the record in this case is capable of the court seeing that the no objection is intended to say, I have nothing further to say. Inartful, and if that's the case, Your Honor, the court could consider this to be an exception to Carr, given the nature of the underlying matter.
So in other words, the context of the other actions in the case should inform our interpretation of the words no objection.
Yes, Judge. And if the lawyer had said nothing else, Judge, or no objection based on prior ruling, the record would be abundantly clear that this was not an abandonment, but simply an effort to be efficient on the court's time, not rehashing what had happened before. And for those reasons, we've asked the court to, within that context, we've asked the court to not apply Carr, or I asked the court to not apply Carr in a drastic sense, unless the court has the abiding conviction that the lawyer did in fact abandon that, as opposed to acceded to a prior fully litigated pretrial matters, which is unfortunately all too common in the trial context, that lawyers don't want to rehash everything, and trial judges don't expect the lawyers to rehash everything. From an appellate perspective, it makes it a little bit more difficult to know if something has been preserved. With
Well,
that,
I have a question about preservation. So to be fair, we do have to follow Carr, of course, but there's an argument to be made that certain statutes can help you out there, even perhaps the text of 90.104, but there's another one, 924.051 about what it means for something to be preserved in, for appellate review. And I just want to get your comment on this one. So going back to the constitutional question, because you're raising problems with Miranda, are the grounds that you raised in the trial court the same or different than they are here on appeal?
Without any loss of clarity, Your Honor, the forceful nature of the constitutional issue raised on appeal was not articulated identically at the trial level. The trial level, the issue made clear, voluntariness was a concern. How that came through, the interpretation of the Spanish to English, the careful identification of the words used, that does not appear at the trial court level. No doubt, defense counsel objected to the statement, objected to it based on Mr. Zolo's lack of knowledge and really total confusion and potential misleading by the police officers, the questioning police officers, who I would say admittedly did not provide the advice that should have been given. The drill down on appeal based on having a transcript, being able to look at it, understanding what happened is far more crystallized. So the short answer in what has been a long answer already, Your Honor, is that we believe that enough was raised on these points by trial counsel, and then appellate counsel has used the law and the appropriate language to demonstrate that Mr. Zolo didn't understand, was misled, and the law enforcement officers used an uneducated individual to push him into a position of wanting to give an explanation. And that's why we believe there is that ill-advised coercion, giving him an opportunity, telling him, I'm entitled to take your sworn statement, as though he has to, and we can use your statements against you, not will. The suggestion being in the appellate brief, not articulated in detail at the trial level, but the practical aspect is that encourages somebody to come forward with giving a statement that Mr. Zolo at least believed was exculpatory. He wasn't going to be giving inculpatory information, things that could be used against him.
Well, the cases in both the federal courts, the state courts kind of go back and forth about can and will. I mean, even Miranda itself, it says twice in the opinion, we hold that. In one place, they say can and will. In another place, they just say can. And then when the Supreme Court affirmed that Miranda was a constitutional decision in Dickerson, the majority opinion said only can. And then we have Florida Supreme Court cases that say only will. For example, I think they're cited in the state's brief. So you're sort of suggesting that can and will are two different things, but I'm wondering whether it's one of those legal doublets, right? Like saying null and void. Isn't the fact that we kind of go back and forth on can and will sort of suggesting that they really mean the same thing?
The question is fascinating. The answer is not at all, Your Honor. And I would say that the literature on this, not cited, the literature on what that means, Miranda revisited after all these years, is fascinating in terms of the analysis by people who understand what words mean. And there are two concepts that show through, not one, that the police have the ability to use it and will use it to avoid any concern that there is some discretionary aspect. Oh, if I say something helpful.
But there is a discretionary aspect to it, right? I mean, because just as a practical matter, the can is accurate. Not everything somebody says is used. The state might decide it's not in their benefit to use it, right? Like it's in fact not true that everything a person says will be used against them. It might be, it can be, but sometimes it is and sometimes it's not, right? I mean, just as a practical matter, the can part of it's much more accurate than the will part of it. It is 100% true that it can be used against you. It's not always true that it will be used against you. There's plenty of times where it's not.
And so the issue here, and I'll say the development of the case law on this, is to avoid a defendant who has to exercise the right, and the right is yes or no, all or nothing until you stop, from not having to analyze, will they use this, should they use it? Just anything you say is going to be used against you. Do you know that? Yes, I do.
But counsel, that's in fact not true that anything you say will always be used against you. It can be used against you. The state does not use every single thing that every single defendant says against them, right?
Correct, but the right an individual has is to know that everything said can and will be used against you, as opposed to an officer saying, now, everything you say isn't going to be used against you. I'll decide what is or isn't. We would agree that that would be a compromising constitutional right. The absence of saying that under the context of I'm here to take your sworn statement, I'm required to take your sworn statement, deludes the person into believing a sworn statement in these circumstances that exonerates me is actually something that, okay, they're not going to use against me because it has nothing to do against me. It only has something to do for me. And it gives the election of that right an improper decision. The person's not electing the right to be silent or not be silent. The person is electing the right to not give them anything that they could use against me. And that's why the articulation of can and will is so important.
Counsel, I think that's an interesting distinction you make. And how does it comport with the fact that the word anything was used twice here? It looks to us like the word anything appears twice in the translation. When they say you have the right to remain silent, anything, saying that twice, does that not give your client a better understanding of the rights that he's giving up by speaking?
Well, it didn't, Your Honor, because under these circumstances, and also note that I've not discussed the improper translation of the right to counsel, but here, after being told, and I say it again, I have the right to take your sworn statement. By the way, this was not even a sworn statement, but had the gravitas and anything can be used against you. I think gave the client the view under these facts and circumstances that, oh, that's what exoneratory statements are all about. They can't be used against me. So that's what I'm going to tell them. And that undermined the will be used against you, meaning whatever you say has a use against you. So that emphasis, whether it was a stutter, not a stutter in a bad way, but just the phrasing, or was intended to be emphasis, certainly doesn't come out like that in the actual play of the interview.
Well, how do we square all this with the fact that he testified at trial?
He did testify.
He did testify at trial, right? So got some statements being used against him, and then you have a competing account of what happened, and the question was presented to the jury, and the jury apparently didn't believe him by the result it reached.
And as the court would evaluate from whether something should be admitted or shouldn't be admitted, if it's admitted, there's a series of trial consequences. If it's not admitted, there's a series of trial consequences. So the right to testify or not testify is equally as important as the right to incriminate or not incriminate. And here, the right to incriminate, not incriminate, resulted in statements being introduced, and the defense position was, I'm going to utilize my right to give testimony. Would that have been the same situation if the statement had not come in? No way to tell, and certainly there's been no suggestion on the record that the trial would have played out that way.
All right, counsel, we've used up most of your rebuttal time. I'm going to give you an extra 2 minutes. I'm going to have to stay an extra 2 minutes since we didn't leave you much for rebuttal.
Thank you, Your Honors. Wait, we ask for a ruling consistent with the request for relief raised in the brief.
Thank you, counsel. State.
Good afternoon, Your Honors. William Schellhart, Office of the Attorney General, appearing on behalf of the state of Florida. I just want to address one thing right off the bat. It's the applicability of Carr. And I believe that my opponent was attempting to distinguish Carr, but I would like to cite what the Supreme Court said. And it's quote, "Here, trials counsel objected to the school records admission at a pretrial hearing, and the trial court ruled that the record was admissible. However, when the state offered the record into evidence during the guilt phase, Carr's trial counsel affirmatively stated, quote, 'no objection,' end quote. In doing so, trial counsel abandoned her pretrial objections to the record's admissibility, and we declined Carr's invitation to revive them." So I know there was some discussion earlier on, well, in Carr, we don't have the procedural history. We don't know what was done below. Here, Carr tells us there was a pretrial hearing regarding the admissibility of certain evidence, that it was objected to, and that when the state sought to admit that evidence at trial, like the counsel here, affirmatively stated no objection. The other part is, I think we have to distinguish between waiver and preservation. The Supreme Court says abandon that issue, decline to revive on appeal. The First District Court of Appeal in Reed, when interpreting Carr, says the defendant waived the right to appeal trial court's ruling on a claim that a recording made by police in which defendant made incriminating statement was inadmissible, where defense counsel stated, again, quote, "no objection," end quote, in response to introduction of recording into evidence at trial. So it's not that it's just not preserved. This is affirmatively waived. This is saying, hey, I think the trial court did something wrong, but I'm going to abandon that. I'm going to say no objection. And then to come up on appeal and say, got you. I know I contested this below. I thought your ruling was wrong then. And I know I told you no objection at the trial, but here I am at the appellate level. And I'm going to say it was preserved. She actually meant to say no further objection, not relying on previous objections or something like that.
You know, 9104 says you don't have to renew your objections, right? When you've made an objection previously, okay, and the trial, and you've got a definitive ruling, right, as happened here and as happened in Carr, and the trial court says any objection. What could you be doing if you were to reassert that same objection? What could that be other than a renewal? It's not a new objection, right? It could only be a renewal of the prior objection, right?
It could be a renewal.
Could it be anything other than a renewal, assuming it's the same objection?
Again, sometimes the record in this case is that the trial court asked defense counsel if they had any further
I
objection.
get it. And if he had said, if the trial counsel had said, I reiterate my prior objection.
That would have preserved the issue. for
Okay,
appellate review.
and that trial counsel would have been renewing the objection, correct?
Yes,
He wouldn't have been launching a new objection.
that's correct.
And 9104 says you do not have to renew your objection, correct?
That's correct. You don't have to renew.
Okay.
But you can't affirmatively say that you have no objection.
But
That's different than renewing versus saying that
So-
you don't have an objection any
so
longer.
what response would have been not renewing, but also not affirmatively waiving? Would it just say, Judge 9104 says I'm not required to respond to you when you ask that? Give me the response that the trial court could have said that would have not been a renewal, but also wouldn't have been a waiver.
Again, the trial court sought defense counsel's inquiry here.
Counsel, don't avoid my question.
I,
Is there
I'm not
any,
trying to avoid it.
is there any words that could have come out of that trial counsel's mouth that would have been not a renewal and also not a waiver?
Probably not in response to that question from the court.
Okay, so what you're saying is it was impossible for 9104 to have any applicability in that circumstance.
No, you're not.
Okay, well then tell me how it could have applied. What could the trial counsel have said that would have given 9104 some
In
applicability?
this factual scenario where you have the trial court judge specifically asking defense counsel, what do you say to this piece of evidence? That doesn't happen at every trial court. It happened here. Before, the state could have said, we seek to admit the defendant's statements at this time. And the court could say, admitted to my prior ruling.
But when a trial judge admits evidence, the trial judge has to ask whether there's any objections.
Not under 91 point, I'm sorry.
So you've seen a trial judge ever admit a piece of evidence and not say whether there's any objections?
Yes,
Really?
yes.
Okay. I've been a trial judge. I've never admitted a piece of evidence without asking for objections.
I've
never seen it happen before.
extensive trial experience, judge.
Okay.
I was a PD for 7 years before this.
Is it proper for a trial judge?
If there was
to
been a
admit
pretrial
evidence?
ruling on admissibility, that no judge in the history of trial courts in the state of Florida has ever said, I've already ruled on that, it's admissible, and doesn't seek the defense's input. The defense could say, Judge, I just want to renew my objection out of an abundance of caution, but there has been that pretrial ruling on admissibility. Here, the court extended a courtesy to defense counsel that said, hey, let me have it. Do you have anything else you want to tell me before I admit this? And defense counsel said, no objection, Your Honor.
But it sort of set them up in a way, didn't it? By saying that, like,
I
providing
think,
that response, I mean, obviously the court had already ruled at pre-trial about the admissibility.
again, there's a difference between saying no objection and subject to my earlier objection. And here, pursuant to Carr, her no objection constituted a waiver or abandonment of this.
But if he'd have said, just subject to my prior objection, Judge, that would have been a renewal, right?
I think we're getting into semantics and
No,
hindsight.
counsel, don't avoid my question. If he'd have said, no, I reiterate my further objection, would that or would that not have been a renewal?
I cannot definitively say.
The only possible response to that question, right, other than no objection, is to renew a prior objection, assuming you're making the same objection. The only possible response you could give to that question would be a renewal. And 9104 says no renewal required.
It's not required. But here, there was an affirmative statement, no objection. And perhaps the court did put defense counsel in a tough spot by saying, do you have any objection to this? And again, defense counsel had multiple ways she could have answered this. She could have said, no objection, which she did, or she could have said, pursuant to our earlier objections. That was a renewal, according to Your Honor's rationale.
Yeah. Do
But
you disagree with me that that would be renewal, counsel? You're saying are you going to look me in the eye and say, I reiterate my prior objections as anything other than a renewal of those objections?
I think reiterating or subject to my prior objections are two different things. Reiterating is restating them, renewing them.
Okay.
Subject to is not saying it again. I'm saying I've already said everything I have to say, Judge. That's what subject to means.
So maybe give us an example of when 90.104 in practice. Is there any circumstance under which it has any teeth in light of Carr, or has Carr really
I think
liberated it?
Carr is meant to not have the sort of gotcha situations that we're trying to avoid here on appeal, where a court has made a pretrial ruling on the admissibility of certain evidence. Again, this is why defense counsel has to renew objections before the jury is sworn. We're giving the trial court one last opportunity to get things right. And if defense counsel has said here, Judge,
Well, at the time they said no objection, the jury had already been sworn at that point, right? Because it's before the jury was sworn when they had the pretrial.
yes,
issue.
Judge, and the only reason I'm using that example is because the appellate courts talk about that's why you have to renew your objection to the seated panels. You want to give the trial court an opportunity to make the right decision the first time. So there aren't retrials based off of issues that the trial court could have properly addressed. Here, it's giving the court one more opportunity to say, Your Honor, I understand you've already ruled on the admissibility. I really think that you're wrong on this issue. Could you please reread blank versus state? We really think that it stands for it doesn't happen here. And that's giving the court one more opportunity.
That sounds a lot like I'd like to renew my prior objection.
Again,
If you think Carr eviscerates 9104, you can just say that. Does it just eviscerate 9104?
No.
We're bound by it if it does.
I don't believe it does. I believe that they can be in harmony with one another. Again, I think Your Honor it's renewing versus and reiterating versus subject to. That's where I would distinguish these two. And moving on further into the issue of these two. Again, the state would argue that these are waived or abandoned, that they shouldn't be allowed to be revived on appeal, but that it's also not preserved. Judge Huey pointed out that the reasons for the motion to suppress below are not the same issues being raised on appeal. There were 3 distinct grounds raised below, 3
Well,
counts.
is it issues or arguments? Let's talk a little bit about that. I mean, there's a difference between an issue, preserving an issue for appeal, and the arguments that you raise to support the issue, right?
Yes,
And then I would think, especially since if there's an appeal, someone lost below and they're going to want to maybe state their argument a little bit differently, right? I mean, do we actually have to have precisely the same argument? Because when I was getting into with your friend on the other side, 924.051, has a definition of preservation that goes beyond just simply having the same argument. You can have the same argument and have it preserved, but grounds isn't that something a little bit different, or issues something a little bit different?
I believe it, the case law says it has to be the specific legal objection raised below. And if I could kind of characterize the arguments on appeal regarding the motion to suppress that appellant has made, is those are challenges to the sufficiency of the Miranda warnings. Below, there was no challenge to the sufficiency of the Miranda warnings.
I guess the coercion, whether it was voluntary or not, right?
It went to whether the warnings were given at all, that he was promised something, and that he was thrown to the ground. There was nothing below argued that they didn't say can or will. They didn't say, if you cannot get an attorney, one will be obtained for you. And there was no challenge to the officer has the right to take sworn testimony. Those are all new issues on appeal.
Does part of it depend on what level of generality you define the argument, right? So if you characterized it as the specifics of he was thrown to the ground, argued at trial versus, the intimidation that the officer basically used with his language here of I'm entitled to take your sworn statement. If you define them that way, they're different. You define them in terms of intimidation, right? They're the same. They're both types of intimidation. So whether or not that specific argument was made doesn't really depend on the level of generality with which you define the argument.
So my response would be,
Like if he had
in
said,
order to preserve,
if he had, and I'll let you continue. I was supposed to say, if the argument here wasn't, he threw me to the ground, or that there was intimidation in terms of the officer's words, it was, well, he punched me, right? And down below, he didn't describe it as a punch. He described it as a throw or a knockdown. Those would be a lot more closer, right? You could still say they're different, but they're closer. You see what I'm saying about the level of
Yes.
generality?
it has to be sufficient to give the trial court an idea of what you believe the issue is. It can't be hindsight a year later saying, oh, we talked about coercion below. That should have alerted the trial court that we had problems with can versus will, that we had problems with empowered to take sworn testimony, and that it said, get an attorney for you or obtain a lawyer for you if we can't get one. It has to put the trial court on notice. That's what preservation requires. We want the trial court to get it right. You have to tell the trial court why you believe that his consent was not voluntary. And these generalities below, and again, there was no challenge to the sufficiency of the Miranda warnings below, not in the motion, not in the hearing, or at the argument concerning the parties. They did not challenge the sufficiency of the Miranda warnings below. Finally, moving on to the merits of the issue, I detailed in my brief can versus will. As Judge Huey pointed out, the Supreme Court wavers and vacillates between the two. The Ninth Circuit Court of Appeals addressed this issue more than a half century ago. That's one step below the Supreme Court. And they said that there's no functional difference between can and will in this context of Miranda warnings. A number of state appellate courts throughout this nation have said there's no functioning difference between can and will. So I would urge this court to not find that can and will are different for the purposes of Miranda warnings. When it comes to obtaining an attorney, again, this was Mr. Zolo claimed he did not speak English. The deputy, a native Spanish speaker, provided him an or a Spanish translation of her English Miranda card. And she told Mr. Zolo, if you cannot.
Does the officer, the translator, being a native Spanish speaker, cut for you or against you? So what I mean by that is there are many different dialects of Spanish. You don't know there's different countries and people from different regions speak differently. When you have a certified interpreter, they're certified in something, right? Whatever the standards for that are. So the fact that it's a native speaker, you can also describe that as an uncertified interpreter who we don't know how they speak, couldn't you? Does that cut for you or against you?
Your Honor, I think there could be an argument both ways. In this instance, I think there's less. And I'll say this, the Miranda warnings are fairly clear cut in English. She's not trying to translate slang or what other people said. She's looking at these Miranda warnings, which are fairly benign in terms of the words used.
I guess what I'm saying is, so when she translated to him in Spanish, she's not translating slang. Do you know whether she used slang?
The record does not support that she did or did not.
Okay,
I have independent knowledge, but
okay, well, don't go outside the record.
that's right.
That's what I'm just saying, like, in terms of with a certified interpreter, I assume through the certification process, I'm not an expert of the process, they're taught to interpret a certain way, right? And maybe not use slang or not use phrases or parts that are specific to particular regions that wouldn't be known to all Spanish speakers, right? Like there's some value to that certification. So when you say native Spanish speaker, it seemed like you were emphasizing that was a thing in an argument in your benefit. And I'm just not sure that it is.
And again, that issue is not being raised on appeal that he didn't understand the Spanish translation that was given. That was the issue raised below, is not being raised on appeal. And then to get to my final point, even if this issue was not waived or abandoned, if it was preserved, if it was error, it was harmless error in that he said it was an accident. His statements were consistent with his trial defense and that
Well, yeah, but he decided to testify once he knew that his confession was coming in, right? To speak about the effect his testimony had, well, it doesn't matter because he testified. Had the confession come in, he might not have testified.
and that's still an accident theory of defense. That's better than an intentional shooting in the face of his wife, which would be attempt first-degree murder.
Well, but what I'm saying is, for instance, to the extent there's inconsistencies between the confession and the trial testimony, right? The jury can hear those and say, he's a liar, I don't believe him. If he hadn't testified, they wouldn't have heard the inconsistencies, right? I'm saying the fact he made all the decisions he made, including the decision to testify, based on knowing the confession was coming in because the trial court let it in, right? It
Yeah,
just seems odd to me to say we can reflect on the error or, alleged error of letting in the confession based on he testified when he wouldn't have testified had the confession not come in.
again, we don't know that for sure, whether he would have testified or not, but a pre-Miranda statement at the scene was that me and my wife had an accident. He interrupted the Miranda warnings to say that it was an accident. And again, there were 5 eyewitnesses to this event. There were the 4 children, the 3 who testified and their child hearsay statements came in, and then the victim testified. There's evidence that appellant disposed of the gun by throwing it in a pond after the shooting. So if there was any error in admitting the statement, it was harmless error. If the court has no further questions, I would yield the rest of my time and ask the court to affirm the convictions and sentences. Any further questions? Thank you.
Thank you, counsel.
Thank you for the opportunity for brief rebuttal. Since the preservation of error issue is so critical in this case, if the court makes the determination that CAR means fully reviewed, renewed objections must be made to preserve something for appeal, we understand. Courts haven't applied CAR in that drastic way. And the context of what happened here was the judge asked for objections. Do you have any objection? Those objections had been had already, and the lawyers simply did what lawyers do. No objections. As though all the objections the judge had previously rejected were all part of this record. That's what trial lawyers understood. That's how trial lawyers act, certainly in the 9-year, I guess it was 8 years since CAR, we're aware of that general rule of abandonment. And if lawyers still misunderstand CAR, that you got to make sure you put a preserved objection on the record, as opposed to rely on what happened before, it really underwrites 90.104, which is what is the active trial rule. You don't have to go through this once again. We asked the court to look at this record and determine that that's precisely what the trial lawyer was doing. Not having any intention of abandoning a critical, heavily litigated pretrial issue that everybody understood had been ruled on already on the constitutional issues. We would ask the court to look at the merits of the issues and determine that under these circumstances, a broad application of CAR did not abandon or waive this issue. Thank you.
Any further questions? All right, thank you, counsel. We're adjourned.